organization that you represent.
Thank you, Mr. Chairman. My name is Gary Bledsoe. I'm president of the Texas NAACP, and great idea to bring Dr. Katz onto our team.
Well, welcome, and please proceed with your testimony, and we would ask you to keep to 2 minutes.
Thank you. To the chair, vice chairs, and members of the committee and the legislature, the highly unusual mid-decade redistricting, like every other one before it, reminds us of the long, unbroken history of efforts to silence and diminish the political powers of Black Texans. We need to remember that this is not just about political parties, it is about the systematic efforts to restrict the influence of people of color in this state. At this nation's founding, the Constitution enshrined the 3/5 compromise, counting Black people as only 3/5 of a human being for the purpose of legislative representation. But while our bodies were counted to inflate the power of slaveholding states, we had no vote, no real voice, and absolutely no ability to shape who represented us, even at the subhuman level. That compromise dehumanized my ancestors, turning them into tools to strengthen the political interests of those who would keep them in chains, and set the foundation for centuries of racially discriminatory laws and practices. With this mid-decade redistricting, Texas is moving back to that era and that system. The DOJ letter to Governor Abbott specifically targets 3 of the 4 African-American opportunity districts where African-American voters are able to elect their candidates of choice directly, and 1 Latino district where Latinos are able to elect their candidates of choice directly. Importantly, the 4th African-American district may have been added for the hearing in Arlington next week, so it seems as though there may be an effort to wipe out the slate in terms of African-American representation in Congress and reinstitute the 3/5 compromise. The 9th, 18th, and 30th are not just any districts. These are opportunity seats protected under the law, as confirmed by both the D.C. Circuit and panels right here in Texas, as well as being admitted to by the state of Texas, even in the current litigation. The 29th is also a protected seat and was originally drawn by the court, as was the 30th, 9th, and 30th. I have 2 minutes. I'll jump to the latter part of my testimony. Some important things for you to note. Senator Huffman testified under oath that the map was drawn blind to race. Number 2, the map was drawn by individuals from the governor's own political party who initially foreclosed attempts for minority input in the process. Then, after they provided limited opportunity, they did not respond to what they heard. Number 3, Senator Huffman said that the Attorney General of Texas reviewed the map and ensured the map did not violate the Voting Rights Act of the Constitution before they went forward with the map in question. 4th, whites are 40% of the Texas population, but control 73% of its current congressional districts. And if they succeed in eliminating 5 districts that are now targeting, the 4 in the letter and 1 more, whites will control 87% of our districts. Since 1980, Texas would have lost seats if the state only used its white population growth to determine the number of seats in which it was entitled. To which it was entitled. Texas had 24 seats at the time and has 38 now. And all 14 new seats can safely be said to be due to Latino, African American, and Asian population increases. The message from history from the 3/5 rule to the present day is that counting bodies alone does not mean granting people power or voice. Our current process risks repeating those old sins by drawing lines that pack, split, and silence communities of color. I'm not here to call anyone a racist, but the actions we are viewing are racially discriminatory. At the critical moment we face now, I urge you to reject any plan that diminishes the opportunity for our communities to participate in the political process. You can stand with Jefferson Davis or you can stand with Abraham Lincoln. The choice is yours. Please reject this idea of engaging in mid-decade redistricting now. Honor the legacy of the Voting Rights Act and let the court decision from El Paso come forward. Do draw maps in the future that recognize the true value and agency of every Texan. Thank you.
Thank you. Members, any questions? Senator Miles.
Thank you, Mr. Chairman. Mr. Bledsoe, I want to thank you for your testimony here today and all of your testimonies and work that you've put in the past for the great citizens of the state of Texas. I just got one question. Can you recall of any victories that the state of Texas has had in courtrooms as it relates to redistricting in the history of Texas in the past?
Well, Senator, that's a great question. Let me give a little history on that because I think it's very important. Number one, our state has a real history of discriminating against black and brown voters, and that occurred even when we had Democratic control. Congresswoman Bernice Johnson famously testified to that during the last decade. But what we have seen is that there's always been a continuation and a history. In Texas, the white Texans went to the United States Supreme Court 5 times in 26 years, from Nixon versus Herndon to Terry versus Adams, to try to prevent African Americans from being able to vote in Texas. And that last case was only in 1953, so it's really in many ways not that long ago. But what we have seen is ever since the Voting Rights Act was adopted in 1965, after every decade's redistricting, people of color have challenged the efforts by the Texas legislature to redistrict, and every single time African Americans and or Latinos have been found to be victorious, and the state has been held to have discriminated against African Americans and or Latinos. And I must say that includes panels like in recent years that are majority Republican panels. So it's not a partisan issue. That just seems to be a predisposition to discriminate against African Americans and Latinos. And so that's occurring even to the present day. I don't know what this court will hold now, where the case is now pending. But indeed, the last decade, the map was found to have discriminated against African Americans, Latinos, as well as in every single other decade. At some point, we hope that the legislature is hopefully going to do right towards Latinos and African Americans, so we don't have to go to court to vindicate our rights. But this is going beyond the pale, Senator, because when you already control 73% of the seats and you want to move that to 87%, I think yesterday Dr. Valenzuela called that apartheid, and I would probably agree with her.
Thank you for that answer, Mr. Bledsoe. One more thing. You're familiar with jingle factors?
Yes, sir, I am.
Can you explain to this body how those jingle factors would apply to Congressional District 18 and 9?
Well,
explain what jingle factors are to my colleagues.
Okay. Well, the jingles factors are when you're trying to create a Section 2 district, there are jingles prongs that you have to meet. And one of those is about whether or not you have numerosity, whether you can get 50.1% of the citizen voting age population in the district that would be of one particular group. Previously, the rule was if you could show various requirements in the Fifth Circuit that you could put black and brown together. So that was the issue that was put together in the Petaway case. So you're looking for 50.1, but then you're looking for cohesion. And so you have to show that they can vote together. And thirdly, that if they vote together, that they would have some success, some electoral success. But you must also show that white voters are polarized, and white voters have traditionally frustrated those voters from being able to elect their candidate of choice. What occurred in Petaway was the 40 plus years precedent by, that we had in the Fifth Circuit by great litigators like Jose Garza and Rolando Rios that brought those issues forth, where you could put black and brown together if you could show various socioeconomic commonalities and political cohesion between the groups, that they could be joined together. And that's occurred until even recent years with litigation in Baytown and other places where that continued to be the rule. And in fact, in the case now pending before the panel in El Paso, that 3-judge panel had ruled prior to Petaway that was a law in Texas, and they had refused to dismiss claims that many of us had made in reference to coalition districts, because until that decision in Petaway last year, that was the law in the circuit. But in terms of what the Supreme Court has not acted upon that issue, but there are a number of circuits that actually still hold that black and brown can be joined together for purposes of creating a district, requiring a district be created under Section 2. And so we're hoping that at some point the Supreme Court does entertain that issue, and that when they entertain that issue, they'll resolve it in the affirmative way and say what we think the law is, that you should be able to join black and brown together. We attempted even last time to join black, brown, and Asian together in Fort Bend County, and we won that initially. We ended up losing it, and the court gave us an encouraging comment in the opinion about the need to continue with the electoral outcomes in the Asian community before we could join all three. But anyway, that has not been decided by the Supreme Court, that you can't join more than one group together. That's only now law in the Fifth Circuit.
And lastly, the ugly truth of the matter is the state of Texas has systematically and historically tried to depress African American and Latino vote in the history of Texas. The ugly truth. Is that correct?
There's a 100% truth to what you're saying. I mean, we didn't have a Latino in Congress, despite the large Latino population in this state, until Henry V. Gonzalez. That was late 50s, early 60s, sometime in that the great the lion Henry V. Gonzalez was elected, and the incomparable Barbara Jordan was there in 1973. But that was after the legendary case, or the important case, White versus Register, that brought us to have the type of single-member districts that allows many of you now to be there in the Texas legislature. So that was 1972. When great lawyers like Dave Richards, George Corbel, and others brought that case forth and required that. So Texas has continued to fight. That it's just like taking teeth from a chicken. It's really kind of hard. You've got to fight every session. Congresswoman Ada Bernice Johnson, when the state senator, she had to go to court and vindicate the rights of African Americans. They did the same thing with the 29th in the 1990s. So minorities have had to go to court to get the districts created, or and so even when the legislature created some, they didn't create them in ways that really empowered the African American community. So that's why people like Ada Bernice Johnson, Sheila Jackson Lee, and others went to court to vindicate their rights to fully establish those districts and make them into true Section 2 districts. And so it took a fight for those things. And so that fight continues. And
lastly, do you view this letter from the DOJ as another ugly attempt to suppress and to downtrot black and brown votes? The letter that's gotten us here today. Is that just another ugly attempt to do the same thing that Texas has been doing historically?
There's zero question about that. It is actually an incredible letter. I think we heard Professor Katz, and she really kind of nailed it. This letter is basically saying that you can't have a district that black and brown people together constitute a majority. So you have all these other districts around Texas where maybe you have, black and white or brown and white or what have you, or you have some combination. But that letter chose to focus on on districts where minorities are able to elect their candidate of choice. And so we don't need to get into all the jingles issues and things of that nature, because the courts have made it very clear that without regard to current statistical numbers, the 9th, 18th, and 30th are protected African American opportunity seats, and the same thing with the 29th. And the 33rd was court created, and clearly the African American community and the 33rd has been able to directly, without coalition, though there is a coalition there, if you peel out the numbers from the coalition, the African American community would still be able to elect their candidate in the 33rd.
Pretty
So
open and obvious and blatant, wouldn't you say? Pretty open and obvious and blatant, wouldn't you say?
It's clear. It couldn't. You don't have to be the sharpest tool in the drawer to understand what this is. This is an act of racial discrimination and bias, and it's saying that we need to go out and you find, it's like creating an amoeba to go out and find black and brown districts and go out and eat them up and eliminate them. And so that's what that says. We found these districts that we just don't like because black and brown people joined together. And so they're going to destroy them. It's completely illegal, and it is race-based. And so they're inviting this legislature to engage in an overt act of discrimination. So if the legislature does what's requested in that letter, they have engaged in intentional discrimination.
Gary, I want to thank you for all.
Gerrymander.
I want to thank you for all the hard work you've done for this great state of Texas, for both black, brown, and everybody included in this state. Thank you, my brother.
Thank you, Senator. Appreciate it. Always say the same for you, and look forward to continuing to work with you.
Chair recognizes Senator Hinojosa.
Thank you, Mr. Chairman. Just a point of clarification on the issue dealing with minority coalition districts. The ruling by the Fifth Circuit pretty much was narrow and point that under Section 2 of the Voting Rights Act, minority coalition district could not make a claim of voter dilation on redistricting. Is that ruling apply only to the Fifth Circuit jurisdiction, or is that nationwide?
That only applies in the Fifth Circuit. I think there's a split in the circuits. I think before that decision, there were more circuits that held that you could join black and brown together. But now I think with that, I think it's apparently evenly split. I hadn't looked at it lately, but I think it's something like 2 and 2 or something along those lines. Not every circuit has addressed that issue for different reasons. But I think that there's maybe at least one other circuit where this newfound Fifth Circuit law is a law, but that's only the law from that opinion as to this circuit. So, and again, you have to draw the distinction, Senator, because they were talking about whether you mandated to draw it under Section 2 by joining black and brown together. But the two big issues they did not address were about, naturally occurring districts, and talked about in Bartlett that we have a right to have black and brown naturally occurring districts just like any other. And number two, even if not naturally occurring, if it's a district that has been a functioning coalition district that was properly created in the past, can you dismantle that? And those decisions were not up before the Fifth Circuit. And so those things are still pending. And that's exactly what they're trying to do. Though, again, I'm going to say 9, 18, 29, and 30 are absolutely African-American Latino opportunity seats and are not coalition seats.
And one last question. The Fifth Circuit opinion in the Petaway versus Galveston County case, they did not address any claims dealing with the 14th Amendment or the 15th Amendment.
They did not. It was only a Section 2 case. It was not about the 14th Amendment or the 15th Amendment. And I'm glad you said the 15th, Senator, because I think some of the courts don't like it when we raise 15th nowadays and maybe dismiss those out of hand. But I think it is the 14th and 15th. And so Where that came from in the letter from DOJ about these being unconstitutional, I don't know. But those districts are absolutely constitutional, and you can look at the opinions that are already in the books that have upheld them, and even the state's expert in the 2011 round acknowledged that those districts were protected opportunity seats. And even if you recall, on the Senate floor during debate and discussion, there was some acknowledgement by state leaders. Even I remember the interchange, I think, between, I think it was Senator Miles and Senator Huffman, where she pretty much acknowledged that on the floor. So I think everybody knows those are protected seats.
Thank you very much, Mr. Bledsoe, for your testimony.
Members, any other questions?
Mm-hmm. I'm on.
Senator Alvarado.
Okay. Mr. Bledsoe, thank you for joining us. What was the process the state said it used to draw the previous maps?
Well, what the sworn testimony from Senator Huffman was that obviously there was a group that was secured that's already been testified to by Congresswoman Garcia, I think, and that group I think drew up the map, and at some point they were in consultation with the Senate leaders on that, and that once they had come up with a map, that map was reviewed by a team put together by the Attorney General of Texas, and that group did a review to make sure that the map was constitutional. So you had Attorney General Paxton that was responsible for reviewing the map, and I think she even said that many times on the Senate floor where you guys were asking her questions, and she continued to say that there's this lawyer that she sends questions to, and while you were discussing things on the floor, they would get information back. Well, it turns out in that litigation, it was the Attorney General's office that was actually doing that. So you would have to believe in the DOJ letter that somehow, if it's drawn race blind and it's reviewed by Attorney General Paxton, that somehow they decided to put in illegal maps that would advance African American and Latino interests, and I think that kind of begs this heart kind of is a bridge too far for me to cross.
So the Attorney General weighs in. The committee had lawyers. There was this group. There were a lot of lawyers that weighed in on the 2021 maps. Correct?
That is true. They had a private law firm. I think you had different representation in the Senate and in the House. Mm-hmm. And I think that the representation during court was, well, the minority can actually get a lawyer too. So we were interested in that. I forget which one of was it Senator or Rep that testified to that, well, you guys could have had a lawyer as well from the Attorney General's office. But no, there were private law firms involved in the drafting and the consulting and all that, and even the Attorney General was involved in that process at that stage. And I think even Senator, there was apparently a law firm that was on site when the congressional map was debated on the House floor. In fact, I think Congresswoman Jasmine Crockett talked about how she had to get their permission before her amendment could go forward and be discussed on the floor.
It seems like if these maps back in 2021 were not legal, were not in compliance with the Voting Rights Act, they were not constitutional, that the Attorney General or somebody in his office, being the lawyer for the state, would have said something. Do you agree?
That's absolutely true. You know, in our opinion, they were unconstitutional, but not because they did too much for black and brown. It's because they did too little for black and brown. So they were also unconstitutional for another reason. And I think I'm I'm not a gambler, Senator, but if there was any stretch of the imagination that they gave unfair advantage to black or brown, they would absolutely have spoken up.
Okay, there were plenty of opportunities for all of these lawyers to say otherwise. Is there a map in the Houston area you have supported, or in the Dallas and Fort Worth area?
If I could just interrupt just a second, and I want to make sure, Senator, you get to ask every question you wish to ask, but I would just want to remind us all that we don't have any map before us today. Today is simply about gathering information from the public, and although we're delighted to have expert witnesses here, the main purpose of the hearing is to gather from the general public. We've got a lot of people in the queue that I know are waiting. We will have, I promise, ample time if there's a map before the committee to go into great detail over that map with all the experts that anyone wishes to bring. And so it might be better to wait for those kind of detailed questions to a different day, but I'll let you proceed at your discretion.
Okay. Again, not my choice to be here. Nobody on our side asked to be put in this situation. So anyway, back to my question. Is there a map in the Houston area you have supported, or in the Dallas and Fort Worth area?
There absolutely is. And I will say with one caveat, because of the rules that were adopted in the Senate last time, and the rules that were allowed, you really could not put forth a map that had opportunity districts, because with the growth in the Latino population, there should have been at least one new Latino congressional seat, if not two. But the way things manifested themselves, the obstacles were too great, and you could not tender maps that provided for that. That being said, there's a map in the Houston area that I think was agreed to by Congresswoman Garcia, Congresswoman Jackson Lee, and Congressman Green, C-2131, I think, and that was something I think that Senator Miles' office might have been involved in helping to draw. But C-2131, because there was so little need to change those three districts, that traditional redistricting principles would say you make those modest changes because they were all three near perfect size. And so you just give some from the 9th and 18th to the 29th that needed a little population. And so that's what we did. And and so that was the one in the Houston area, because it adhered to traditional redistricting principles. And C-2177 in the Dallas-Fort Worth area, but only as to Congressional District 30. The changes there to 33 are not changes that we support or propose, but in terms of, because Congressional District 30 should be a majority African-American district, but the state decided to diminish it by 2.5 points or so in terms of the African-American population. But so that C-2177 that was tendered on the House side but was not adopted. It was tendered by Congresswoman Jasmine Crockett when she was in the State House. So we support those two, but we say there needs to be at least one Latino opportunity district and maybe two. Dallas-Fort Worth had the largest growth of any metropolitan area in the United States of America. And the Houston area was only about 50,000 behind. So there's tremendous growth in both those areas. And the huge growth that Texas received was 50% Latino. And so I think that the Latino community definitely deserves additional representation.
Is there anything inconsistent with the position taken by Governor Abbott in the recent trial with what President Trump is saying today?
Absolutely. They can't both be telling the truth. They were race-based or they were race-blind. You can't be race-based and race-blind, right? And so one of them has got to be as to fundamental untruth. Okay. They can't be both true. They were race-based or race-blind. I would like to say, just Senator, for the record, even Chief Justice Roberts, I think in the Milligan case, talked about how you need to look at race, but race shouldn't dominate, but you want to avoid discriminating against African Americans and Latinos. And in fact, the legislature is advised of that in the 2021 manual put out by Ledge Council, though I think Senator Huffman said that they didn't really desire to follow Ledge Council direction on that issue.
I'm interested in what you have to say about the 3/5 rule. Can you explain that to us?
Well, that's when you use bodies that have no political power to get more districts. And so when my ancestors were enslaved here in Texas, up in, the Falls County area, what have you, where my folks were enslaved, they were counted for numbers, but they had no political power. And so Texas was able to get additional seats. That was a big issue in Congress at the time, and there was a big debate about whether to continue that, because what happened was the 3/5 rule gave disproportionate power to the southern states, and that helped lead to, no doubt, the Civil War. So you can say you have 1 million slaves, and even though they have no vote, you can count them as 600,000 people for purposes of getting new districts. So you have all these new districts. So that gives white Texans greater power than what they would have otherwise as a multiplier as to their power, simply because of their being able to use people who were enslaved. And I think that parallel exists today, where you have such a large immigrant population, an immigrant population that one can honestly argue was really kind of invited by business to come here and to be part of our state. And so that population is used to drive up the numbers of seats that Texas is permitted to have under the Constitution, but they can't vote and things of that nature. But what happens here is that you get the marginalization. People can't vote, but what makes matters worse now when they can vote is they're still trying to do the same thing as before, to draw districts where African American Latinos would have no influence and not be able to elect their candidates of choice. That's exactly what the DOJ letter says. Mm-hmm. It's upset that black and brown can get together and elect their candidate of choice. But that's what the 3/5 rule is, that you simply use people for numbers but disregard them otherwise. And I feel that that's what's actually happening as has happened in our state. And if we adopt what the president's recommending here and go to 87% of the districts being controlled by white voters, I don't think we can even argue that point at that time.
Okay. One last question. This process of mid-decade redistricting, will it potentially put some Republican seats at risk?
There's no doubt. I think we saw what happened in 2018, Senator, with the changeover to Congressional District 7 and Congressional District 32. Those were considered to be safe seats for a decade, but that didn't work. And so this time, what occurred was, instead of just using the suburban areas, which are now diverse, and so because of whether it's financial gains or whether it's just people moving in from the outside who chose to go to the suburban areas, our suburban areas now are very diverse. And so that's why you have a Congressional District 7, a Congressional District 32 that can upset what had thought to be an effective racially gerrymandered map. And I think that's the concern that many have here. The New York Times reported that many of the members of the Republican delegation who met with President Trump on this were not in favor of it, and they were unnamed sources for the New York Times article. But I think they can see what happened, because what happened this time is they went about as far as you can, in my mind, although I think one of the witnesses said they could go further. But when you start doing things like Congressional District 13 going like over 400 miles from one point in the district to another, including 38 counties, where you now add the rural areas and you cut up the minority areas and you pack them into a limited number of districts, and then you crack out the rest of the minority community in the urban areas, and you extend it all the way to rural areas now, so that those rural districts can then control the vote along with the sympathetic voters from the suburban and urban areas. And so that's the ploy that's taken here. But, it can definitely backfire like it did last time. And I think that's what those lawmakers understand, because even the current one that's there could backfire at some point, where they've only taken 73% of the districts. But if you take 87%, I think that's going to be quite volatile. But the only problem with that from our viewpoint is we still want to have black and brown opportunity districts, which you'll probably end up with is a whole lot of potentially Democratic districts because they're trying to grab too much. And so you have to stretch the white voters so much and so thin. And you can't do that, Senator, without involving yourself in racial gerrymandering. They're going to have to use race as the means to draw a new district. So it's going to be a textbook example of racial gerrymandering.
Thank you, sir.
Senator Hinojosa.
Thank you, Mr. Chairman. Just one question, Mr. Bledsoe. What is the difference between an opportunity district and a coalition district?
An opportunity district is where your group can elect a candidate of choice without having to go to another group for a coalition. So, for example, if the African American voters, even though they may have a coalition with Latino voters or Asian voters, if you look at the African American vote, and if they're able to elect their candidate of choice, then that would be an African American opportunity district. Now, for the first creation of such a district, you've got that 50.1% numerosity requirement there. But districts have continued to function that way, and the courts have ruled that they continue to be, even if they drop below the 50.1%, because they continue to function in that way. A coalition district is when you need to join with another group that would be needed in order to get the majority. So those seats, you could have black and brown, brown and Asian. You could have whatever percentage of minorities to have a minority coalition seat in whatever combination that could do, as they were doing in Galveston, where that lawsuit brought by I think 3 NAACP units and a LULAC chapter, along with an incumbent commissioner, challenged that. But they had a coalition, and they were able to get the candidate of choice over time. And so that's a coalition district. Now, neither one had the ability to do it on their own, but where they can do it together. And you have that other district that we saw Professor Katz talk about. That's a crossover district, but that's where you have sympathetic or in line, in sync white voters, and you have to add them to the quotient. So when you add white voters, it becomes a crossover district. And that's the one that was talked about in Bartlett. And they said, well, there's not a constitutional a right to preserve, to create a crossover district.
Let me just stop you there and get back to the opportunity district. I understand the other two, crossover and the minority coalition districts. The opportunity districts, do they combine? Does it have to be 51% or 50% plus minority?
For the initial creation under Jingles, that is the requirement, 50.1 CVAP.
And there would be an opportunity district?
That would be an opportunity for the initial creation. But what I've said, the courts have held that districts that have fallen below that but still function in that manner are still opportunity districts, even if they drop below, as long as they continue to function as they were prescribed to function.
And that would be without any type of coalition with another minority group.
Right, and it doesn't mean you can't have a coalition, but the question is whether you could, without the coalition, elect your candidate of choice.
Got it. Thank you very much, Mr. Bledsoe.
Thank you, sir.
Thank you, Mr. Bledsoe. Appreciate you being here today.
Thank you, Mr. Chairman.
Ladies and gentlemen, I know it's noon and we still have a lot of people in the queue. I'm going to continue to call people up in groups, and then if you'll just, once you're kind of moved over into the waiting area,